to be filed with the petition as an alternative to an affidavit, expands the court's ability to continue the hearing on the petition for good cause, and a few more sentences. Director of Public Safety, or Martha?
We're going to ask Dr. Mitchell to testify, please.
In support, right?
Yes.
Welcome.
Chairman Sparrow, Vice Chair Baker, Senator Green. The department stands in strong support of this bill. I'd like to give a little background. I'm not going to reread the bill to you. I presume you've taken a look at this. About 5 years ago, we entered into a settlement agreement with the Department of Justice regarding corrections at OCCC for mental health care. Under the strong encouragement of the Department of Justice and their expert evaluators, we put a statute in place which allowed us to provide involuntary treatment to mentally ill offenders. In the process of implementing that, we found that we had some challenges, and some of the people that we intended to get the treatment to, we couldn't get the treatment to. Specifically, there were people who were in long-term segregation. And when I say long-term segregation, I mean 20 years, 17 years, literally in isolation with no treatment. One of the problems was that they never reached the degree of imminence because they couldn't get out. And so we were in a catch-22. So what we've done with this law is it expanded the definition of imminent harm so we can actually get treatment to these individuals and get them out of segregation back into the general population or into mental health care even. So that is probably one of the largest things that we've changed in this bill. Most of the other issues are housekeeping issues related to language. So we stand in strong support of this because we consider it somewhat inhumane to keep these folks locked up with no treatment, which is essentially why we got sued at OCCC to begin with. And I don't think we want to go through that exercise again. So.
Interesting concept, isn't it? Okay, treatment. Okay, huh?
Yeah, treatment. Amazing.
Okay, let's move on. Thank you, Dr. Mitchell. Department of Attorney General. Support?
Deputy Attorney General Richard Stacy for the Department of the Attorney General. I did submit testimony. Good afternoon.
Yes, that's why we called you.
I am also in strong support. I do these in court, and we have run into some problems that we're trying to address. We're usually in front of Judge Perkins at First Circuit, and this, I think, will help speed things along. We had some successes on 2 recent cases, I was told by the Halava medical people that they've been a real success story. But we're trying to get moving faster, and this, we think, will help a lot. So we're strongly urging that this go forward.
Thank you, Richard.
Thank you.
Is there anyone else that would like to provide testimony on Senate Bill 1179? Members, any questions? If not, we'll move on to Senate Bill 1181 relating to committed persons on furlough. Adds child support payments as obligations for inmates on furlough who are employed, and delineates percentage of earnings that shall be deducted to satisfy outstanding orders regarding restitution, crime victim compensation, other fees and fines, and child support and reimbursement to the state for the cost of room and board. Department of Public Safety.
Martha Torney, Deputy Director for Administration. I'm reading or coming up to the table because I realized I did not amend our testimony following a discussion with the Child Support Enforcement Agency. Gary Kemp from that agency will be testifying very soon. We put a limit of 30% on child support. That, in fact, violates federal law. So we do ask that this bill be amended on page 2, line 1. It should only read child support orders, semicolon, and we ask that you delete the language from line 1 to 3 to be paid at a rate of 30% of the net monthly earnings or the amount ordered, whichever is less.
Thank you. And Troy, an individual in support. Attorney General.
Welcome. Chair Sparrow, Vice Chair Baker, Senator Green. My name's Gary Kemp. I'm the administrator for the Child Support Enforcement Agency. I think Martha just did my testimony, basically. So
You can pay her later.
The bottom line is that the Social Security Act requires that we deduct the maximum amount from the paycheck of an obligor up to the Consumer Credit Protection Act limit, which is 50% for some, 60% for others. And so the 30% limit that's in here is a problematic, and the amendment that she suggested, which is also depicted in our testimony, is what we would like to see.
Thank you.
Thank you very much.
Thank you, Gary. Is there anyone else that would like to provide testimony on Senate Bill 1181? If not, members' questions? So we will make the amendments as suggested by AG and Public Safety. Senate Bill 1183 relating to intake centers provides pretrial bail reports to the courts on adult offenders that are consented to by the defendant or that are ordered by the court, and amends the law to provide statutory authority to the courts to treat information contained in the pretrial bail reports as confidential. Department of Public Safety.
This Department of Public Safety supports this administration bill. It is going to make a correction that we inadvertently made through the JRI Act last year, where more or less by changing language, we deleted bail reports, the responsibility of bail reports, and this puts it back in there. They have that responsibility and may carry those out. Thank you.
Thank you, Martha. Is there anyone else that would like to provide testimony on Senate Bill 1183? If not, members, questions? If no questions, final agenda item, Senate Bill 1182, relating to the service of process. Update the statutes to authorize persons authorized by the courts to serve legal process. Department of Public Safety. Keith, welcome.
Welcome, Chair. Keith Kamita, Deputy Director for Law Enforcement. This is our second bite at the apple to fix this bill. After talking to the Attorney Generals, we had to take out a word that said rule, because process was only dealt with in rule and didn't address the other 5 items. So this bill would fix that problem, plus make all the language consistent throughout the statutes. Thank you.
Thank you, Keith. Judiciary? I hope someone's here. Oh, good. Susan?
Yes, Susan Pago-Cross.
Thank you, Susan.
I think they need a third bite at the apple, because we don't feel like this bill fixes the problem. Instead of making it incumbent upon the rules that don't really address the issue, it requires the judges to authorize civil process servers. And we spelled out in our testimony, we don't feel that's a good idea, because the judges don't have the training, the expertise, and there's no criteria to determine how a judge should go about determining that a process server is authorized. And finally, it was just pointed out to me that it also kind of presents a conflict of interest situation, because judges are often called upon to question whether process has been affected and whether it's legally affected. And if they're actually in the position of appointing the process server, it might be a conflict in terms of determining whether or not that process was effective.
Thank you, Susan.
And one more thing, we just would point out also that there is another bill that's being circulated that we do like, the Senate Bill 311, and I think it's House Bill 1280, which proposes the working group to study things like the process of registration and certification of process servers, and we think that's a far better approach, and we would be happy to cooperate with that process.
Thank you.
Whoops, thank you.
Why don't you sit tight for a moment? I don't think. Is there anyone else that would like to provide testimony on 1182? If not, Keith, why don't you come up?
Sure. Hi.
Okay, so you don't like his suggested amendments. So you're saying the judges, it's too much work and effort for them to come up? Because previously, who decided on the service processors?
It was they had a list provided by the sheriff's department.
Yeah, but that ended a year plus.
I understand, but how difficult is it to get on that list and to be qualified for that list?
It was the way the original process was that when this first started, they were bonded and all that, and it kind of deteriorated as it went along. And pretty soon it was just the process server authorized, or the attorney authorizing that process server in a document. So there was really no way that public safety verified that this guy was qualified. We also found that a lot of the individuals on that list were, some of them were felons, so they should never have been serving process. There needs to be, like they said about the 311, the study would help determine what's the criteria.
Would you prefer that over the existing bill?
I think we're going to need a little of both. We need to fix some areas, because right now, in areas of the law, only sheriffs can do certain process. We wanted to add in police, and that's what some of the areas in this bill does.
And then there's also the other persons authorized by the court,
Right.
which there are no.
Right now there isn't, but we're thinking it sets a ground rules for the next step, which would be if the court decided or a body decided that how we're going to qualify process servers or people who serve writs.
Vice Chair.
Yes.
My understanding is that when we had the issue of a lot of foreclosures and people were being evicted from their properties, that sometimes those were done by sheriffs, but other times they were done by some kind of organization who I could hear them advertising on the radio that they would come and evict and take care and do all of that. And that makes me a little nervous, because if the court has ordered somebody to get out of their house, that's one thing. Mm-hmm. But just to, have a landlord go to somebody and evict them without some kind of making sure that they have the authority to do that makes me wonder if we don't need some qualifications, somebody to take responsibility for it training, knowing how to read the process. And I don't know whether that's a good use of the sheriff's time or it should be somebody else. I'm just not clear on it. So I'm kind of thinking, Chair, that I think we need to do some study, because it makes me nervous the way I hear it's actually going. And I talked to some of the sheriffs, and they weren't totally comfortable either. So.
Okay. Any further questions, or did someone want to respond? No? Okay, thank you.
Thank you.
I believe that completes our agenda. So we shall recess for decision making.